The last lecture that will be given today will be Maurice Cullity's lecture on remedies in estates, wills, and trusts. Maurice Cullity was educated at the University of Western Australia and at Oxford. He taught estate planning and related subjects at the University of Oxford, Western Australia, Melbourne, Pennsylvania, and since 1968 at Osgoode Hall Law School. Mr. Cullity has been called to the bar of Middle Temple in England, to the Supreme Court of Victoria in Australia, and here in Ontario. And since the beginning of this year, as I understand it, has entered private practice in Toronto with the firm of Davies, Ward, and Beck. Ladies and gentlemen, Mr. Maurice Cullity.
Ladies and gentlemen, Paul was talking about Lord Denning's reformist tendencies. And he reminded me that in the last couple of months there's been a letter written to the Times newspaper in England by a Mr. Francis Benyon, who apparently has been provoked beyond endurance, and he called for Lord Denning's resignation on the ground that if you compared the number of times the Court of Appeal has been overruled or reversed by the House of Lords in the last 4 years in cases in which Lord Denning has been sitting, with the number of times it's been overruled in other cases, the discrepancy is quite enormous. And that, as you'd imagine, that letter started as letters normally do in certain times of the year in England, started a flurry of correspondence. Some people wrote in and said, "And who, pray, is Mr. Francis Benyon?" And someone else wrote in and said, "And who, pray, do you have to be to challenge the Master of the Rolls?" And eventually Lord Denning was approached, and he's reported to have said, "I have all the Christian virtues except that of resignation." Now, I'd like to thank Professor McCamus for not stealing all of my topic. I'd also like to thank him for dealing with the hardest parts of it. It was suggested to me that I should focus on remedies or recent developments in remedies against estates, and I have accepted that suggestion in my paper, but at the beginning I'd like to say something about the question of classification of trusts, and I'll try to be very brief. I'll do this because it's something that John kindly left to me. He knows I have strong, and I suspect that he thinks erroneous opinions on this particular topic. The emphasis in John's paper, and I think the emphasis in the articles that will be written on Becker and Petkus, will be on the constructive trust. And I want to focus on the resulting trust because although the cases seem to indicate or suggest that it's of declining utility and that certainly it's been overshadowed by the new constructive trust, I think there are problems which have not been resolved, and that particular remedy may be useful not only in the area of matrimonial property, but in the area of claims against estates and in other areas. But I have to admit at the beginning that I am still very puzzled, very baffled by some of the things that have been said in the recent Supreme Court cases about resulting trusts. And when I went to law school, which wasn't such a long time ago, I was told that resulting trusts arose from presumptions of intention, or they arose because somebody had made a disposition which failed to exhaust the beneficial interest. But in the Canadian cases since Murdoch against Murdoch, we find repeated references to resulting trusts arising from common intention or express or implied agreement. And these statements, which are continuing, you'll find them in the judgments in Becker against Petkus that John discussed. They're reminiscent of quite a celebrated statement of Lord Halsbury at the end of the 19th century in a case called Smith against Cook. Lord Halsbury is reported to have said, "If it is intended to have a resulting trust, the only proper, the ordinary, and the familiar mode of doing so is by saying so on the face of the instrument. And I cannot get out of the language of this instrument a resulting trust except by putting in words which are not there." Now, with the modesty and the politeness that attaches to all people who are born in Australia, I'm not going to comment on that particular statement, but I will refer you to a comment made by the present editors of Snell's Principles of Equity. And one of those editors, of course, is the Vice-Chancellor of England, Sir Robert McGarry. They refer to it and they comment quite dryly. They say the concept of the resulting trust at times appears to elude the common law mind. And if any of you have that marvellous volume by Sir Robert McGarry, Miscellany at Law number 1, if you look at page 143, you'll see an even more critical comment about that same statement on the resulting trust. The aspect of the statements in the Canadian cases that bothers me is simply that it seems to be accepted here now that if the parties, say to a marriage, agree that a particular property will be owned by them beneficially in certain proportions, that can give rise to a resulting trust, and the beneficial interest will be shared between them according to the proportions in which they agree. In other words, the trust arises from the agreement, and the quantum of the beneficial interest of each party depends on the terms of the agreement. Now, I don't believe, in fact, I would be prepared to argue for a long time, but I'd be the only person here, I suppose, if I did it. I don't believe that that's the position in England at the present time. I don't believe that's the position anywhere else in the Commonwealth, and I don't think you can support that on the basis of traditional principles. To be really pedantic, the word resulting and resulting trust comes from the Latin verb resultare, which means to spring back. And a resulting trust can never, on orthodox principles, give you a beneficial interest which is disproportionate to the amount of your contributions. Your beneficial interest in your contributions springs back in the form of a beneficial interest in the property that's purchased. That, as I understand it, is the traditional view. It's clearly not the law in Canada at the present time. I could cite you many dicta which it's not the law in Canada if we believe that judges mean what they say. For example, a statement of Mr. Justice Martin in the Court of Appeal here in Whiteley and Whiteley: the proper test in determining whether a trust arises is whether the words or conduct of the parties satisfy the court that it was their common intention that the beneficial interest was not to belong solely to the spouse in whom the legal estate was vested, but was to be shared between them in some proportion or another. In other words, the test is simply, did they have a common intention to share the beneficial interest in certain proportions? And I could quote other statements to a similar effect. This is not the position, as I've said, outside of Canada. How is it that our law has gone off on a tangent? And I'll indicate in a moment that I think there are practical implications in this Canadian development. The explanation is simply that in Gissing and Gissing, as John McCamus mentioned a while ago, Lord Diplock referred to a particular trust which arose from common intention. In England, in Australia recently, it's been recognised that that trust was a constructive trust based on equitable fraud. The parties had a common intention that the beneficial interest would be shared between them. One person made contributions, acted to his detriment on the basis of reasonable expectations. It was held that it would be fraud for the other person to go back on the common intention. That's the way it's understood in Australia and in England. In Canada, however, from Murdoch and Murdoch, the courts have said that, or have indicated that they are interpreting Lord Diplock as referring to a resulting trust. The notion of reasonable expectations or detrimental reliance has been dropped, and we now apparently have a resulting trust which arises purely from an agreement, an oral agreement, or a common intention. Because it's called a resulting trust, in orthodox terms it would be an express trust, but because it's called a resulting trust, it's not subject to the requirement of writing under the statute of frauds. And I'll say more about that a little later. I want to turn now very quickly, and I invited Mr. Lamech at the coffee break to go over his time if he felt like it. He took advantage of that. I only did that because I knew he would go over his time, and I didn't want him to feel bad. I've seen him perform before. I promise you I won't go over my time. In the paper, I have dealt with remedies against estates, as it was indicated that I might do, and I've interpreted the term remedies in a fairly broad sense. I thought of contractual remedies brought against personal representatives or against an estate, including a few problems which I think may arise from the provisions of the Family Law Reform Act dealing with domestic contracts. talked about recent cases on informal contractual claims generally against an estate. I've talked about the use of the constructive trust and resulting trust as a remedy after the death of one of the parties, and we've got close to that position in some of the reported cases so far. We haven't quite got there yet. And finally, I've talked also of the main differences or the main changes in the dependence relief or support provisions of the Family Law Reform of the Succession Law Reform Act, and how they interact with the constructive trust and the contractual developments. And then finally, in the paper, which as you will see is far longer than it should have been, I spoke about the remedies that a beneficiary who has been overlooked by the personal representative may have against the personal representative and against other beneficiaries. And I went into that area because of the abolition of the distinction between legitimacy and illegitimacy, and the fact that personal representatives now have a duty to go out and make reasonable inquiries, to sweep the bushes, to try to find anybody who can trace a claim, whether that claim is to be traced through a birth inside or outside wedlock. Well, now, under the first of those topics, it's perfectly clear, of course, and has been clear for generations, that a person can make a contract to leave property by will in a particular way. He can make a contract not to revoke his will. If he breaches either of those contracts, his estate can be liable in damages, or in a proper case, specific performance can be obtained. Well, now, under the Family Law Reform Act, as you know, we now have provisions for domestic contracts. And domestic contracts, three kinds: marriage contract, separation agreement, cohabitation agreement. Each of those can deal with property rights on death. And as far as the definition of the marriage contract and the cohabitation agreement is concerned, the Act specifically says the parties can agree on ownership or division of property on death. Now, I think there are two main consequences of these new provisions. One is a public policy issue. I presume that because we're now told that you can have these contracts, it's no longer possible to argue that a contract which assists people to cohabit, though not married, or a contract which contemplates the breakdown of a valid marriage is against public policy. I presume that's fairly clear. I think probably the far more important point about these contracts is in section 54, which says that a domestic contract is void unless it's in writing, signed by the parties, and witnessed. And the question is, what is a domestic contract for the purposes of section 54? Is it possible that spouses can make any contracts affecting their property rights which do not have to be in writing, signed, or witnesses? The Act doesn't give us much help. It says, for example, a marriage contract is a contract entered into under Section 51. Section 51 says two people can enter into a contract during their marriage in which they agree upon their property rights on death. Section 54 says a domestic contract is void, not unenforceable, void unless it's in writing, signed, and witnessed. Now, the problem has not been faced squarely in any of the cases so far. Section 54 has been looked at, and the courts seem to be assuming that any contract is caught by it. And if that's so, you have to be careful, I presume, if spouses are parties to a buy-sell agreement or a shareholders agreement. Normally you'd have their signatures witnessed. There are going to possibly be problems if you don't. I find it difficult to believe that if husband and wife go in and sign a contract to buy a house in which they're going to take the title in equal shares, that contract is void as between them if they don't get their signatures witnessed. But there's a problem sitting there, and it's something of a trap which will have to be resolved in the future. And notice that, as I said, that the court says that the statute says that the contract is void. You'll remember that very shortly, within 10 years of the enactment of the Statute of Frauds, courts of equity had invented the doctrine of part performance to prevent a person setting up the statute to commit a fraud. But the Statute of Frauds doesn't make a contract void. It's going to be very difficult for a court to invent a doctrine of part performance that will prevent a spouse relying on Section 54 of the Family Law Reform Act in order to perpetrate a fraud in the sense in which courts of equity have used that term. In other words, you mislead somebody by entering into an oral agreement, that person acts to his detriment. Normally that would be a fraud in equity. But it's going to be difficult for the courts to do that with Section 54 to give relief in that situation unless they zero in and the plaintiff zeroes in on the new remedy of constructive trust and possibly resulting trust. I'll say something about that in a moment. There's one final point I'd like to make about domestic contracts. In one of the excellent services which have appeared on the Family Law Reform Act, it said if you enter into a domestic contract which purports to dispose of property on death, make sure you have it executed as a will, because it'll be testamentary. And I don't think that's correct, and I'd be horrified if it was correct, because it meant that every time you made a new will, you'd be revoking your domestic contract, presumably, or I don't know. I don't think it's right anyway, because the law of wills, of course, is concerned with testamentary dispositions. It's not concerned with contracts. And if I enter into a contract today in return for consideration, and I promise you that on my death I will make a payment to your kids or to you, that contract comes into existence immediately. I don't think there's any question of it being testamentary in nature. It's not a disposition of property. It creates a personal obligation. On contractual remedies in general, there have been numerous cases of the familiar kind, the common law spouse, or the housekeeper, or the child who looks after the house, looks after the parent. Parent leaves the property to somebody else. The child comes in and says, he made a contract with me saying I could have it. If he didn't, I should succeed on a quantum meruit. If I can't have it on a quantum meruit, I'm going under dependence relief. And now the new variation, he'll be saying, and what's more, there was a resulting constructive or implied trust, and it's not necessary to distinguish between them. In these new cases, the courts have generally indicated that they will be reluctant to find a contract unless there's clear evidence that the parties intended to enter into legal relations. They'll be reluctant to find a binding contract unless the terms of the agreement are clear. And there are cases in which the courts have found contracts. There was one case where they found a letter written by the father to the son to be a sufficient memorandum to satisfy the statute of frauds. Another case where the judge indicated that he might have allowed a revoked will to be introduced as a sufficient memorandum. Unfortunately, the revoked will had disappeared, and when the parties tried to give oral evidence of the written document which would satisfy the statute of frauds, this was not permitted. The most interesting development, I think, in this area is in the law relating to part performance. Statute of frauds is a barrier whenever somebody makes a contractual claim against the estate unless he has a memorandum in writing or unless he can establish part performance. The approach taken by Canadian courts traditionally has been, in terms anyway, a fairly strict one. The acts will not amount to part performance unless they are unequivocally referable to a contract of the particular kind. In Stedman and Stedman in the mid-1970s, the House of Lords simply, it's one of those cases in which everybody gave a long judgment, and you can generally find a majority on the side of the angels, but the composition of the majority seems to differ from time to time. But generally speaking, the House of Lords rejected the unequivocally referable test. They said as long as, on the balance of probabilities, the acts proved indicate a contract, that's sufficient. The balance of probabilities. Two of the judges said, and as long as they indicate any contract at all, that's sufficient. The other judges were a little more concerned. One of them left it open. Two of them said, no, it's got to be a contract of the particular kind, or at least a contract affecting land. But the unequivocal referability test has gone in England. It remains to be seen whether that will be followed in Canada. And the other point, I think, that comes out quite clearly in Stedman and Stedman, and which I think is consistent with what's happening in Canada in the resulting trust and constructive trust area, is that a majority of the House of Lords says part performance isn't just a rule of evidence. The court isn't simply saying, well, you don't have the evidence required by the statute, writing, but we'll let you bring forward this other evidence because it's just as good. The House of Lords, or the majority, say the basis of part performance is this old notion of equitable fraud, detrimental reliance. One party has been induced to act to his detriment on the basis of some assurance or common intention. It's the same principle that you see in the constructive trust area. Now, moving on from contractual remedies very quickly to the constructive and resulting trust as remedies against the estate. There's nothing in Becker and Petkus, and you'll notice that I can pronounce it. I don't run into those alliterative errors that Professor McCamus was having difficulty with. I've been sitting down there practicing and praying that I wouldn't. You'll notice that in Becker and Petkus, there's nothing there to suggest that this remedy is confined to matrimonial property when each of the spouses is still alive, and in principle, there's no reason why it should be. And as I suggested a moment ago, I would think that, if you put down all the possible remedies that the person who's been disinherited has relied on in the past, at the end of it now, you might as well tag on the new trendy constructive trust, and I would suggest also that you keep in mind the resulting trust. Now, just take this situation. Suppose husband and wife or cohabiting parties have in fact made an oral agreement, or the court is able to infer a common intention that they will share the beneficial interest. The title is acquired in the name of one person, but the other spouse also makes contributions. It's clear that that is a domestic contract and it can't be enforced as a contract, because section 54 subsection 1 says void. But if we are to take literally those statements that I referred you to earlier, that in Canada a resulting trust can arise just from common intention or oral agreement to share the beneficial interest in particular proportions, then clearly somebody is going to argue, and he's not going to be without support in the authorities, somebody is going to argue it may be void as a contract, but it's a good, sound trust. A resulting trust a la Murdoch and Murdoch, Rathwell and Rathwell, and the minority in Becker and Petkus. If you can't prove the common intention, then there is the constructive trust, which in Becker and Petkus we find is apparently limited. It only gives you a remedy proportionate to your contributions. So it's not quite as good as the resulting trust if you can get the court to accept the resulting trust. So the constructive trust, based in the recent judgment of Mr. Justice Dixon, to some extent on frustration of reasonable expectations, getting a little bit close to equitable fraud, the principle at the basis of part performance, that may be available as a method of countering a defence based on section 54 of the Family Law Reform Act, a defence that an agreement was not witnessed or in writing. Clearly, however, it's not as sweeping, doesn't extend as far, won't cover as many cases as the as the doctrine of part performance. Now, just a couple of questions about the use of the constructive trust after the death of one of the parties. First question is, when does the trust arise? I guess from my assumption is from reading the judgment of Mr. Justice Dixon, although there's a lot of talk about it being just a remedy and not a real trust, I presume it arises during the lifetime of the parties. It doesn't arise on death or when the application is made to court. On that basis, the beneficial interest should have precedence over the rights of the beneficiaries to the estate, and it should have precedence over applications for dependence relief. On that basis also, some very old law relating to election seems inevitably to arise. I haven't got time to go into this. I've discussed it in my paper. There's a recent case out west, Schillebeer against Deagle, in which on fairly similar principles, or fairly similar facts anyway, the court felt obliged to put a spouse to her election. But if I have, by working so hard on the house which belongs to my wife, I have acquired a beneficial interest under a constructive trust. She leaves me the residue of my estate and leaves the house to my daughter, and I claim a constructive trust interest in the house. I think almost certainly I am going to be forced to elect either to take the residue and lose the house, or take my share of the house and compensate my daughter out of the residue. That's pretty old law, but it hasn't changed much in the last 150 years, so even the textbooks you acquired when you were at school will probably be accurate enough. Question of statute of limitations or limitations periods on the constructive trust. Again, to some extent it depends upon whether this concept is to be regarded as sufficiently analogous to an express trust or to a claim for money had and received. A pure restitutionary remedy. Again, I guess the cause of action will be said to have, most likely be said to accrue when the equity arises. Sorry, the trust will accrue when the equity arises. I do not believe the cause of action would accrue until the party with the legal title acts inconsistently with the other party's claim. If that doesn't happen, if a cause of action accrues when you make a contribution, then presumably time starts to run every time you make a contribution. And I don't think that's the way it's going to be looked at. If it's true that the cause of action doesn't arise until the party with the legal title acts inconsistently with the rights of the other, then I think the trust will probably be regarded as an express trust for the purposes of Part 2 of the Limitations Act, and there'll be no limitation period if, for example, the owner of the property, the legal title, sells it and keeps the proceeds. Finally, on support of dependents, tremendous differences have happened to me since I ceased to be an academic and became a practitioner. When I was an academic, I could never say anything in less than 50 minutes. Now I find it's comparatively easy to get things into 30 minutes. As far as dependents' support is concerned, there are three questions, I think, which are worth looking at. One is, can a dependent contract out of his or her claims under the Act? Second one is, can you defeat a claim under the Act by contracting to dispose of your property? And the third one is, does the constructive trust or resulting trust remedy take precedence over the remedy under the dependents' relief provisions of the Succession Law Reform Act? And the answers to those questions, as Lord Justice Scruton said, no doubt will be short, sharp and wrong, but they're going to be short and sharp. I think you can contract out of your right to go under the Succession Law Reform Act and apply for support. No one will be a dependent now unless he is either supported or unless the deceased is under an obligation to support him immediately prior to the deceased's death. By contracting out of your obligation to support, I believe you, in effect, bar your rights to go under the Succession Law Reform Act, Part 5, on the death. Second question, can you contract to dispose of your property on death so as to avoid an order? And the answer to that one is a peculiar one. It seems that if you make a promise to leave property to X on your death and you perform it, you actually leave the property to X, then to the extent that the value of the property exceeds the consideration provided by George, the property goes into the estate and the court can make an order against it. But if you contract with George to transfer the property to him and you breach your contract, you don't perform it, then George comes in apparently in priority to the jurisdiction of the court under dependents' relief. So if you want to defeat the rights of your dependents, by leaving property to somebody, you contract to leave property to that person and then make sure that you don't do so. That doesn't make a great deal of sense, but if you look at Section 78, which is designed to deal with this problem, they have limited it for some reason to cases where the contract is not performed. And finally, with constructive trusts and resulting trusts, if I'm right in my gut reaction that these things will probably be regarded as giving rise to beneficial interests prior to the death, then I presume that those beneficial interests will not be subject to an order for support under Part 5 of the Succession Law Reform Act. I carefully chose the more boring parts of my paper to inflict on you. I thank you for your patience. I'm sufficiently a practitioner now to remember to tell you to address all subsequent complaints to FC Maltman & Co. Thank you very much.